Yeah, I went in today, I spent probably 6 hours today. I reviewed all the records. Turns out that all those records were in fact here. None of the records that had supposedly been lost were lost.
They've been telling Roger for years that they were all lost.
Since 2014. But in 2014, sometime during that summer, can't tell you exactly when. Well, I can tell you when the prosecutor was there to turn the records over. And they went down and collected the records. But no one knew they were here. Whoever picked them up,
And
which I
nobody-
don't know that.
And nobody bothered to tell Roger. The brother was working on him, but it's me, but that's new.
That's true. But whatever you saw, where I can tell you when it was.
7:30 and we're
I
recording.
can't.
It's 7:30.
We're back. Anyway,
7:31.
we do have the records.
I'm not here.
All right, 7:30. Let's call the meeting to order, and with that, this. Hold that close. All right, everyone, open up your mic. If you haven't got it on, I just turned mine on. DG?
All right, Mike Kavler,
Here.
Johnny Manson,
Here.
Virginia Lewis. Here. Tom Need,
Here.
Brittany Hooper. Here.
All right, thank you. The workshop meeting for the Harlem Township Zoning Commission is now in session. And you heard the roll call of the members. We have no alternates currently. We're seeking alternates. So if there's any member of the public out there that would like to find out more information about that, please let us know. And it's a simple process. So if you decide you'd like to be an alternate to the board of zoning commission, you just submit an email or a letter to the township trustees indicating your interest, and then there would be follow-up after that. For those of you who may be participating via Zoom, do we have some?
You have a couple.
Yes.
We have. Yeah, we
Good.
have two additional.
You'll get their
besides
names
you.
recorded, or you,
I'll get their names recorded.
all right.
Yeah.
And for purposes of the meeting here, did you put out a sign-in sheet in the back?
There's a sign-in sheet.
So any members of the public, when you came in, if you didn't put your name on that list, please do so, so that we will have a record of the public present tonight. For the conduct of the meeting, we would ask that you wait to be recognized. And if you are recognized and you wish to speak during the public portion of tonight's meeting, please come up to the podium, state your name and your address. And the reason for that is that because we are recording the meeting, plus we have people who are participating in the meeting via Zoom. And that will then become a record of all of our participants. At this time, we're going to move to, we'll introduce the public officials who are present. We have Scott Sanders, who's the director of the Regional Planning Commission. He's here for our workshop. We are planning on discussing things that we have been working on, 4 articles of the current zoning resolution that we are looking at changes, and Scott has been assisting us with that. And we're planning on doing that tonight. Scott will be leading that discussion. And then the other person that we have present is our newly elected, he's not yet serving as a trustee, but Matt Yeager is here. He was elected in November and will be starting as a trustee in January. So, our secretary, DG Wolf, over here on the left, she will be answering potentially some questions. She will record information and she will call the roll as that is necessary. Now, moving on, The item that we listed on here, Eckhart's Ventures LLC, had some questions, which I was surprised Mike's not here, but I didn't discuss specifically whether he's planning to be here. I thought he was. That was just an assumption. Indicated Mike Cannon, our zoning director, indicated that there would be some questions about adding a garage on a house that was recently, the property was recently purchased, located at 11225 Gorsuch Road. Who's here to do that? Okay, thank you. What could you state your name for us, please?
Let me come up there.
Yes, please do.
Brian Eckert
Okay, Ryan, thank you.
Brian.
with the B.
With a B, sorry, I missed the B.
You're good.
Brian. And it's Eckert Ventures LLC.
Eckhart's
Is the
Ventures.
property.
Yes,
It's in that name.
yes.
Okay, well, before we go any further, there's some information that I want to share with you relating to this that I don't know how much you're aware of. So let me just tell you that today I spent a total of about 6 hours reviewing some records that had, until I went and reviewed today, had been told repeatedly for the last 10 years that they were lost.
Okay,
They weren't lost, but they definitely were misplaced. And they were found, and I don't know exactly, I can't tell you exactly when they were found, but the records are here. So we have a copy of the PRD as it was approved by the zoning commission in 2002. So we know for certain now that it is a PRD. There was some doubt and some questions about that, and it's regrettable. I know that these records that were found they were misplaced because a previous zoning inspector back prior to 2014 had removed some of the records to their personal home, and that person passed away. And then there was difficulty in retrieving those records. It took a letter from the county prosecutor's office to the widow indicating that she was required to turn those records over, and they were picked up. But when they were picked up, I don't know who picked them up, whether it was the zoning inspector at the time, one of the trustees. But the records came back to this building, but no one, let's put it this way, none of the zoning commission members, and there's only 2 of us, I think, that were here in 2014. Were you here in 2014? No, I didn't think so. We've been told that those records were lost. They were not lost. They were just misplaced. And anytime that someone refers back to that period of time and mentions that the records are lost, no, don't take that as gospel. The first step that needs to be done is you go to the zoning office, you ask the zoning inspector and our zoning assistant, DG, they will look into the files, and that's how these records are now in the files. But this has only been reorganized within the last 3 months, that records that were just in boxes stored away someplace were taken out of the boxes and have actually been filed so that things can be found. So with that said, I want to ask you, Ryan, and I'm going to pass out a copy of this to the members of the zoning commission because they need a copy. This is a copy for you in case you don't have one, Ryan. This is a copy of the existing text of the planned residential development. This is a development plan that was approved
In 2002.
in 2002. That's correct. And so I know it was an issue for regional planning that you were dealing with at various times too, relating to that. I don't know whether you have a copy of the text on file up there, whether you would normally keep it there or not.
It would depend if the township, after the approval, if you send the approved copy, or if we still have the original. I was fairly new at the time, so I don't remember that.
Yeah, well, I wouldn't expect you to remember. I mean, 20 years ago.
I remember.
Would you want this copy or do you want to have us
I can- if it's
send it up
accurate, I
to
can
you?
figure that out.
Yeah, and then you can just see if it's on file. All right, I wanted everybody to have that because we've had some discussions about what to do with this property, which I don't know how that's been filtering back to you, Ryan. You haven't spoken with us. I know that you've talked with Mike Cannon.
Yep,
And then, of course, you would have talked to the previous property owner, or a representative of the previous property owner. Roger Nybarger, I understand, has been the representative, the pastor of the church.
yes.
He wasn't there back in 2002. That was
Okay.
a Reverend White at the time. The other thing, which I'm sure that you probably have, but I want to, again, Ryan, I want to make sure you have a copy of it. This is the lot split, the transfer. It's going to be recorded. I don't know if it has been specifically recorded yet or not. I know regional planning submitted it to the recorder's office.
Well, we don't do that. The applicant has to
Yeah.
actually get it recorded.
Well, adjacent property transfer memo, and who'd you submit it to?
We get probably Mr. Neebarger. I mean, I remember that name. I think he would have been the one handling it.
An email copy was sent to our township zoning inspector.
And I mean, so it's just coincidental that I'm here tonight, but we approve lot splits and adjacent property transfers throughout the county in the township areas. So the only reason that we were involved in that is that they presented that it had been two parcels for a long time. It just appeared to be one. And when they tried to go and record just new versions of those two, that it got kicked over to our office. So we didn't send them through the normal process of proving that they were both buildable because the evidence was that they had been two parcels before. So we used that transfer language, even though it was basically a split, but we were just acknowledging what had been in place.
Yeah, because it was approved as a part of the PRD, it's approved as 3.14 acres, which is a total of 0.5 added to the larger parcel, which wasn't sold. The only parcel sold that Ryan purchased is the 0.5 acres. And so that's why you were dealing with this in terms of approving, getting a transfer situation set up. And I know that the prosecutor's attorney has communicated that that was appropriate in terms of the sale. Because Roger, I remember expressing concerns about whether they could move forward with the sale of the property, and yes, so that's happened. I just wanted to make sure that everybody got that information because I didn't have it until today. And I went through books and I've gone through everything that is there. And these copies that I'm passing out to everyone tonight, I want you to have it because now we're going to listen to what it is that Ryan has some questions about.
So
Go ahead.
I would like to add a garage on the house to make a 2-car garage. But before I submit the application and waste the time in the paperwork, I would like to know if that's even feasible.
Yes, I guess you would want to know that.
So my plan would be to come towards 25 feet off the house towards the shared drive, which would put me really close to the property line of the shared drive.
Okay.
So the way I believe the documents are wrote right now is that we share a driveway. That house has no driveway.
Yeah, well, when it comes to a planned residential development, which is now, we know the zoning that's on the property. The, what you're talking about would be a modification to the existing development plan. That's this. And, proposing a modification of that nature, there's two levels for a modification. There's a minor modification and a major modification. And, or it's considered to be as a major modification when the amendment or modification to the approved development plan represents a substantial departure. And then there are some substantial departures from the original application, and they are listed in the document. Have you reviewed this part?
I haven't even seen these things before.
Okay. Well, there are 9 specific items listed relating to what you're asking about. I think,
Let me just break in. Brian, I think Mike is referring to the actual zoning article.
oh yeah, I'm sorry, I was.
This one?
No, the actual zoning article. It's article,
Rezoning.
it's article
Yeah,
11
through
planned
some of it,
residential
yes.
district.
So
It
that's,
doesn't make any sense to me, but
okay, but that's what Mike is talking.
That, when I asked you the question, I'm sorry, I didn't apparently communicate that clearly enough.
Just to
Thank you,
confirm,
Tom,
this is
for
a
making
PRD.
sure he's understanding.
This is a PRD,
Yes,
right?
yeah, Article 11.
The article is a
A
PRD.
PR, no,
Article
the,
11, but the property is a PRD. The answer is yes.
okay, thank you.
I couldn't answer that question until today.
Mhm.
For certain. But now I am certain that it is a planned residential development. That's the zoning that's applicable. So to answer your question about how to proceed, you are with the right board to deal with a planned residential development because it's a modification of what was approved 20 years ago. If it were to PRD, you would be a non-conforming lot. And it would require that you get a permit as well, but you would be going to a different board. You'd be going to the Board of Zoning Appeals.
Okay.
The property previously was zoned, according to the records that I found today, was previously zoned FR1. So when it was approved for a PRD, the change was from FR1 to PRD, planned residential development. The church had tried to go the route of a variance initially through the BZA. The BZA actually granted them the variance, but the problem was the structure that they would approve or would allow wasn't big enough. Because they were basing limited it to 25% of the existing property or buildings that were there. And this structure that they wanted to build was larger than that. So that's why my understanding from looking at the records is it ended up going to the PRD. So the whole process was followed. They went to preliminary meetings. And after the preliminary meetings, they had a hearing. And it was approved by the zoning commission or recommended by the zoning commission to the trustees. And the trustees approved it. The hearing by the zoning commission was on July 29th, 2002. When they recommended approval to the trustees.
So basically, though, now that we know it's a PRD, we just have to decide whether this is a substantial or minor
For
modification.
tonight, thank you. That is correct.
go.
That's the question I think that we need to answer for Ryan tonight. Is it a major or is it a minor modification?
Well, if you look in the resolution, it says an increase in overall lot coverage of structures and off-street parking. I would say that's under a major. I would say that a garage probably qualifies under that.
It's covering part of the property that wasn't covered before.
Yes.
And how big of a garage? You said a 2-car?
Yeah, just a 2-car,
You know the dimensions that you have in mind?
roughly 25 by 26. The house is 26 wide or front to back. So I would just extend that 25 feet.
So you're looking at adding it as an attached garage.
Attached, yes.
Okay.
There's obviously room in the back if that's. If
You know
this
where
is
your
not an
septic is?
option, we could go into the back, but I don't know where the septic is. That leads into the septic. I mean, right now that they don't even have any off-street parking.
Yeah. You've already got the septic system is located. You know where it is.
I see where the tank is, yes. Where the leach bed is, I have no idea.
Okay, well, obviously that'll become it, not one specifically for us, but you'll have to know that. You'll have to know that, and we will want to see that in terms of the of the development plan. Modification.
So then your big question is. Since there's that property line that goes down that shared driveway. Are you gonna run into setback issues if you put that garage on the side?
The zoning commission can grant a divergence. Yes, you look at the original plan, they granted some divergences at that time.
Are both parcels owned by the same people or no?
Not now. He owns the 0.5 acre parcel. The 2.6 acre parcel is still owned by the church.
That's the
So
church.
then do both parties have to be present if we're going to grant this divergence? Because it would be closer to their property.
Well, they would certainly be notified in terms of knowing what is being done.
Yeah, but do they have to be in agreement with it as well?
They have to sign a petition. My reading is that they both have to sign a petition to move forward with the application for the divergence or for the.
Well,
change
especially
to the
since they
development.
want both use the same driveway and the driveways.
So I believe that the shared driveway is already wrote in the deed. That
Is,
it's- we are allowed to share the driveway. That's how the purchase contract was written.
Okay,
Okay, is there room to put a new driveway in on the other side of the house, on the west side? Access, have you go gain access that way?
No,
Not without I don't know how much space there is, but it would require
roughly about the same, if not even smaller.
well, in order to move the whole process forward, the first step is this a major or a minor modification, board?
I think it's major.
I would agree.
Is there anyone who sees it as a minor? Okay. Then, Ryan, what we're saying to you is it's a major modification, so that would mean there would need to be changes in this written narrative. Part of the change is gonna also need to be identified that the 3.14 acres has been separated into 2 parcels. A 0.5 and a 2.64. 0.2643, I think. So that the other parcel, all the rest of this would be applicable. There's a lot of this that won't even be applicable to his parcel anymore.
Yeah,
Right. One of the points I think that Mike will make is that what we need is a development plan that looks like what you have in your hand from
Okay.
2002, most of which will not change because it doesn't have any application to your half-acre parcel. But it's got to be in the development plan anyway.
Okay.
So when you rewrite the development or you write the development plan, you have to pick up most of what's in the current document and simply make changes to what you want to change on your parcel.
Okay,
Okay, and that, so what we will have is an updated development plan, a new dated development plan, which supersedes what you have in your hands now,
okay,
even though the changes relatively only impact your parcel.
okay.
So I think, you got to keep that in mind in terms of what we're expecting back from you.
Yeah,
When he does this, does he go through the same preliminary meeting process as well, or does this just come back as a development plan?
No, basically because of what the procedure that's followed is he would go through the full procedure, so to speak. He can come back. And
Well,
go
and I
through
haven't done a
everything.
PRD, does that require,
Um,
um,
well, the modification, the request for minor changes to the development plan may be approved by the zoning commission without being subject to the same procedures
Oh, we
as
just
the
said this was
original
major.
application.
Yeah, this is a major,
So it's a major, so it's subject to the same procedures.
yeah, and I don't know those well enough, but does that include preliminary meeting? Cause I feel like
Well,
we don't have a bunch of good answers for him, so to
It-
send
it-
him off on his own without,
this is not a requirement. It's not specified as a requirement,
okay.
but it is certainly something that is encouraged.
And I would encourage you to work very closely with your neighbors who are the other part of the PRD.
so the rumor has it, which I don't know if true, but that church is coming down. I don't know if that's true or not, but the rumor is on the street is the church is being tore down in the next 30 days.
Which is,
We don't know anything about that at this point. But
So
if
then
they're,
maybe hold off for 30 days and then come back with it.
if they're planning on modifications on that parcel, then again, the same thing would apply to them in terms of, it's a PRD. So if they're planning on some new construction of some kind,
I
Yes.
believe that their intentions is to keep the rear church and tear the front church down, which would be right at the road. I believe,
okay,
but I don't know
we
that.
haven't heard anything about that. I mean,
Yeah.
that's news.
That was just like rumors.
Yeah,
Whether it's true or not, I have no idea.
well, as this would be applicable to them and whether or not they, based on my conversations with Roger, I haven't had one with him since I've reviewed the records, but previously he told me he didn't have any narrative that described or a development plan. So he may or may not have this.
I don't think he does. Last I talked to him,
Okay,
he didn't have any records, wasn't even certain it was a PRD. Because nobody could find the record.
and the last conversation I had with
Okay.
him, that was what I indicated, that I wasn't yet certain that it was a PRD. Granted, that's what it shows on the regional planning map, that it's a PRD, but we didn't have any records of that. We do, in fact, have the records. So this is something that Roger definitely needs to be aware of.
Yeah.
And the
Agreed.
process that needs to be
Yeah.
put in place.
So as far as I see it, I think the garage is certainly something that is potentially attainable. But I think with the difficulty of it being two separate landowners on one PRD. If I were you, Brian, I would seriously consider those preliminary meetings because I think there are going to be a lot of questions that come up throughout this process, because it's a strange one to have two owners and one PRD.
I don't think there's a point of having preliminary meetings until we learn about what's gonna happen on.
The fate of the church.
Yeah,
Yes, I think there is some sense in that as well. I'm not sure how quickly you're wanting to do this, but
So if I propose the garage, is a shared driveway like the biggest thing that makes it a major?
no.
No,
It's
the
the-
construction
it's
of
the
your-
construction of the garage,
Okay,
the additional structure. Because you're talking about 20 by 25 feet,
26.
so you're talking approximately 500 feet. The square footage in the house.
it's 1,000.
So that, and you're covering part of the parcel. So the way that the PRD was originally approved, that wasn't in the PRD.
But I think the shared driveway issue is going to be less of an issue for us since it's all one PRD. and more of an issue for the other parcel owner. And so that's why I think, you know, we're not gonna have a ton of answers
And if
until we
it's-
know what's happening on that other parcel, because you know, it's sort of up to them whether or not they let you get that close to that shared driveway.
And the other part about the shared driveway, has it been approved as a shared driveway through
It's
regional
in the
planning at this point?
deed,
You know, you probably don't know offhand, those
Separate
guys,
easement. It's a separate easement that I signed. with
because it would be
Sorry, didn't mean-
No, it's okay.
I'm sorry, go ahead. You can come up and speak there with, are you married? Is this your husband? Your
No,
co-owner?
Business partner. No, at closing, what happened was a shared driveway easement agreement was signed. Between both between Roger and I. And it's a very typical joint driveway agreement.
Is that something that has to be approved through regional planning? No, because it's just,
No,
Just
Two
an
lots.
agreement between me and Roger.
there were
So-
multiple, more lots it would go through.
So is this residence, is it going to be used as a residence and the garages will be used for the residents?
Yes,
Oh, the people living in the residence,
yes,
it's not gonna be a
Business.
garage for a business.
no,
Well, at this point, we have concluded that it is a major modification. So the way that it would have to be approved would be to go through the normal steps of getting an application approved for a planned residential development. Now, as Tom has already iterated, this is the existing plan, and the only thing that you would need to be concerned about would be the changes that you want to see in here to address what you want to do on the property.
okay,
If the other property owner wants to make additional changes, then that property owner has to get themselves involved in this process as well with
Okay.
you. But they don't have to bring, I'm not telling you that they have to bring one in.
so I just
Still
make the
one- there's still
modification to
one-
this and fill out the application, I assume that's online.
Yes, the application is online.
Okay.
This would be an amendment to the township map
do you have that application?
form that you'd fill out. Submit
It
it.
seems like an unusual application
Yeah, I
for you to
don't,
have ready to go.
I know, but.
this wouldn't be an amendment to the
Zoning resolution says is that it go through the normal procedures. And that
So
would
just
be
a reason.
filling out the application and going through the steps of developing, having the development plan, submitting it, we'll schedule a hearing. Yeah, they submit an application, we'll schedule a hearing, and then we go through it. So the application that's used, that's the only application we have for all of the zoning districts, unless we're specifically referring to the planned residential conservation district or an overlay district.
And I think we will still need something from the other parcel owner, even with that shared drive easement stating, you know, it's okay to not have our traditional setback from the shared drive.
If that's what he ends up proposing.
Yeah, just most of this is going to be just for you, but you will have to have something in there saying that.
You're gonna have to look at and have some work done. You don't necessarily have to have a detailed surveyor do it, a professional survey do it, but you're gonna need to identify on the property, the site plan, where all the structures are and where you want to, and what the setbacks are that you're proposing, because those will be the questions that we would be asking.
And, yeah,
Anything else?
no, I mean, you can use us as a resource. You can use the zoning inspector as a resource. But you should carefully read both of you should carefully read the zoning article and understand what's in it and understand what's required. Because that's all we have to go by. We have to determine whether it meets the zoning resolution or not.
Yeah, and I read through the PRD, it does not, as far as what I saw, I didn't see any setbacks.
I'd
I could
be
be
surprised if they're
wrong.
not.
Well, the setbacks would be in the,
Chapter
It-
one,
the, they're in this,
And there,
they are approved in this.
Back to 20.
it's 21. yeah.
Any place that there was a divergence, the divergences would come from the development standards. So you're looking at, you need to look at Article 11, and then you would look at the development standards.
Which is Article 21.
And that's to Article 20. Thank you. Article 20.
I know I'll be encroaching on any setbacks. I mean, it's pretty obvious if I go that way.
Yeah, but again, you have an odd situation, so
Yeah.
if you can get the other parcel owner to agree to that, then if it's all one PRD, I don't see why that would be an issue from our end.
No, it would be for us specifically.
Yeah, so if you have their sign off on that, then I wouldn't think it would be a concern.
But if you, in the future, if you want to sell the property, you need to make sure that if your setback is smaller than normal, that it's written in the planning, in the development plan, so that it's legal,
Okay,
right? Because that development plan is basically the zoning on that property,
okay.
right? So it's, you learn about zoning while you're doing this,
That's no problem.
and then you'll join the committee.
No,
How long does this process usually, like if I,
it'll
What's that?
take anywhere from 90 to 120 days.
okay,
And if you want to schedule a preliminary meeting with us, then you can make that request and we will schedule that. We could schedule it in January.
okay,
And then following that, in other words, you come in with an initial kind of development plan, taking this document and making the modifications that you see as appropriate. We'll talk about it with you informally with that, and then give you the opportunity to go back and then makes any changes that might be suggested and bring it back before you actually submit the application.
okay,
Okay? And that way then you would be getting additional feedback, because this is a very unusual set of circumstances. We ended up where we are. Some of this discussion could have taken place a long time ago had everyone been fully aware of the documents that are available. They weren't, but now we are. So this is what we would be dealing with.
But you only meet monthly. You only meet monthly. Sometimes you have a workshop a second time in a month, and that's part of why it takes a while
Yeah,
to get through the process. Just,
that's correct.
Cause
That
then
would-
once it goes from us, it also then has to go to the trustees who only meet once a month.
Yeah, the
Okay.
trustees only meet once a month. That's the reason I'm saying 90 to 120 days. It's because
Mhm.
of the
And most
nature of
often
the way our
longer than
meetings
shorter.
work. And, we have a preliminary meeting, then we schedule a hearing. Now you're looking, that's, we're talking about 60 days there. And then the trustees would schedule a hearing, that's another 30 days. So from now, we're looking at probably 120 days.
Okay.
Yes, you have a question?
What would you like to see from Mr. Nyberger? You say sign off on, what do you wanna see? Is something like an agreement says that he doesn't have any problem with the, being within 1 foot of the property line?
Oh, in terms of,
'Cause actually it was.
when you get the proposal with regard to specifically what it is that you would like to do and have that in writing, then get the agreement from him relating specifically to that. That if you're encroaching on,
Have a previous agreement or something like a boilerplate document where.
I don't think we have boilerplate for anything like this.
we don't. No, the zoning commission doesn't, the township doesn't.
I would imagine it could look quite similar to your shared driveway agreement that you have. Just something that, something along those same lines. Again, this is an unusual PRD, an unusual split. This is something we haven't dealt with before, but anything that. And if you wanted to consult legal counsel to have them draft something up, I would think that would be sufficient.
Yeah, or you can try looking online and see if you can find anything online that would, as a free legal advice online with regard to
Got it.
forms that might be available?
Yeah.
I have
yeah,
no
we
idea
don't-
whether
We
there's
don't have
something like
anything.
that out there.
Yeah, I think in the township right now, there are only 2 PRDs. You're one of them and the other one has more likely 20 or so houses on it. So you're a very strange animal and we're trying to wrap our heads around not only how it happened, but how we deal with it now going forward, so we don't stand in your way. But there still are legal requirements in the zoning resolution that we have to follow when we make a recommendation to the trustees. We're only a recommending body. We don't decide anything. We recommend to the trustees, they make the decision. We have one hearing, they have their own hearing. So it's a long drawn out process. One thing I would say, again, going back to the article, this is section G in the article, it's page 1106. It says a request for modification of an approved development plan, which is, there is an approved development plan from 2002. A request for modification of an approved development plan may be submitted to the zoning commission by the owners of the proposed development. There are none, right? Or by signed petition from at least 51% of the current property owners in the development.
And that's the reason Tom said earlier, it takes your signature and the other person's
There's
signature.
only 2 of you,
There's only
and
two.
51% of 2 is 2.
50% isn't enough, takes 51%.
Right. And again, you know, if we have to go back and read these documents very often ourselves because we don't have them memorized, but do the same because you're going to have to read what we read and understand what we're trying to accomplish here.
Yeah, ultimately, I'm sorry, go ahead.
No, just so it's not exactly on your point, but even to get this thing started, before you deal with the driveway or the structure or anything, you have to get Roger's signature on a petition to us, allowing you to modify the existing development plan.
Got it. Got it.
And then you can talk to him about, does he have a problem if your
Garage
garage
is-
is closer than 15 feet or whatever the setback is?
And the time to submit that to us will be when you request the preliminary meeting.
And if at all possible, I would talk to Roger and tell him when these meetings are being held and ask him to attend. It makes no sense to me to be doing a whole bunch of stuff that he doesn't know what's going on. I don't think he's gonna object to any of this stuff anyway.
No, that's very good information. The certifications that we've gained this evening are very helpful. Ultimately, what we'll be doing is renovating the home. It's a beautiful area.
There's one other thing that I want to make sure that you're aware of, and that is because there had been discussion with the county prosecutor regarding this before, not what we're talking about tonight specifically, but the issues of lost records and so forth. At that time, to the zoning inspector, the county prosecutor recommended that the trustees consider waiving the fees associated with this modification. Because we're looking at fees that would approximately with from your property, $1,200 application fee, plus the acreage fee, which is small, so it's
Very tiny.
and then the preliminary meeting is a $300 fee. So we're looking at $1,500 or so, but I think the trustees will probably waive the fees. And it's because of all of the problems with the discussion about records being lost.
It's worth asking.
And if they do waive the fees, please do a preliminary meeting because I think that will help all of us understand how this PRD works and make sure we have a PRD that works for you and Roger and is good for
So
everyone.
don't skip that step, because obviously we're dealing with unknown situations here. We have not dealt with them previously. And I know that from the discussion I had today with regard to the fees with the zoning inspector, that recommendation came to the trustees and they will consider that. My understanding is they will be considering that at their meeting on the 20th. So that if you move the process forward with an application with the request for at the time that you make that, that's when the fees would be. there's nothing that you need to know other than the fact that so on the 20th, after during the trustee meeting, that's when they would make the decision.
And they meet at 7 p.m., correct, or 7?
They meet at 7 p.m. on December the
Here.
20th here.
Yes.
Yes.
And that's when I need to have this.
No,
No,
that's when.
no,
that's
you
when
don't-
they
you
will
don't
make a
need
decision
to-
on whether or not they're waiving the fees.
I got you.
That's the
I need to
only,
fill out the application prior to that.
no, you do not.
They will simply make that determination at their meeting, and then you can proceed how you choose, knowing whether or not there will be fees associated with it.
Yeah, it'll be a motion that the trustees would deal with.
So I come to that meeting and ask them to waive.
You're certainly welcome to come to that meeting and support.
I got you.
It
Of
sounds like
that
they'll be making a
request.
decision on it regardless of your attendance,
I got
but
you.
if you attend, then you know your answer.
Okay.
And I'm going to suggest that we as a group, we will go ahead and make a recommendation to the trustees
To waive
that the
those.
fees be waived due to the history that got us to this situation. So they'll get a recommendation from us for that to happen. And they, at least one of the trustees knows about this and is expecting the recommendation to be forthcoming.
Sounds good.
All right,
Thank you.
good luck. We'll see you again in January, I think.
Yes, thank you.
You're very welcome.
Why they went the PRD 20 years ago, I don't know why.
Um,
I mean, you explained it well, but it still doesn't seem like that was what they should.
it's just,
I mean, some townships have a planned institutional district that lets you define better what to do. They could have made the argument that they were a church and didn't really
Yeah.
need to do anything
Well-
but meet the setbacks.
Parsonage originally,
Yeah, that's what I figured.
long time ago.
we don't know how many other situations there may be out there where the records that had been lost, I'm glad to know that those records, that whatever they were, have all been turned back in and they can be now found. Because they're in the filing cabinets here. So, if anything that might have happened prior to 2014, don't make any assumption about lost records anymore. Assume that all the records are here rather than the other way around. Because I've been operating for 10 years with that as part of the basis that records were lost.
Right.
And it turns out none of the records were actually ever declared lost by a court.
Right.
Never.
Yeah.
Even though that rumor also has gone around.
Yeah.
That never happened. So
Okay.
any reference to lost records from this point forward, ignore them.
I got a question. Do we
Okay.
know, have the trustees authorized us to continue having regional planning work with us through into 2024? Or do we need to make a specific request?
I'm going to actually submit that to them. To Kendra, as an item to be on the agenda.
Okay.
Because
Yeah, I don't think our contract is limited by time.
Okay,
There may be a dollar amount, but I mean, we can work
That
through
probably-
that because it's not the point of
Yeah.
the project.
Does
I
that be said every year? I don't know.
It can, if we have a conversation and talk about it, because you have that, so many hours. a year.
I don't remember what the contract, how the contract specifically reads now. I mean, we'd have to pull the contract out and look, and I haven't done that.
We have it. I'll check it.
But it was something that thank you for bringing it up. It was something that I thought about, that we need to make sure that the trustees, if there are any additional fees that may be involved, that the trustees would authorize it to be continued.
yes,
Because
but we've been making good progress, I
We-
think, with Scott's help, and I'd hate to lose momentum on that.
yeah, definitely. And so far as strategic planning, we will not be having 5 new strategic planning articles forthcoming. If they produce anything, it won't be 5 in number.
Was that a question or a statement? Tom looks unsure.
Demand.
I haven't seen anything like that. I'm not working on anything like that, so, no, maybe,
Oh,
no.
that was another question. Are you meeting on January the 2nd? Strategic planning?
Probably not. Carl was sending out a note asking why don't we move it back to the 9th,
Okay,
to the second Tuesday of the month. And I said, zoning was not meeting on the 1st, and as far as I know, we're not meeting, with no intention of meeting on the 2nd. We're gonna meet on the 9th, or I'm sorry, on the,
we've already set that.
on the,
yes.
on the 8th is gonna
We
be our
agreed
first
on
meeting.
that, that we're meeting on the 8th.
Yeah, and maybe the 22nd if we want a second meeting in the month, but it's, if they want to meet on the 2nd, if they want to meet on the 9th, it shouldn't be a conflict.
Yeah. The 8th will be our regular meeting,
Right.
and then if we meet again, the 22nd, we'll schedule that as a workshop.
Workshop.
Okay. Coming back to where the main reason or the reason that you're here, Scott, the articles. Article 9, low density residential district. We had received the final clean copy of that. So the question is, are there any new questions for Scott? We're ready to move this forward. Can we say that this one then not that we're going to schedule a hearing for them tonight, I don't mean that, but I want us to come to an agreement that this one is ready to move past the stage of review.
Went from the R2 or to, yeah,
Yeah, R2,
yeah.
Article 11. This is a clean version
Mhm.
based upon all the changes that we've made over the last several months.
I only did spot comparisons, but I didn't check every single line from the old red marked one. But it looked fine to me.
Yeah, well, that was my reading of it.
Yeah, I think, the only thing we brought up were some of the numbering, and words and numbers. We talked about that last time, I think. And whether we need I don't think we need to discuss it. So,
Oh, you're talking about like,
Where you write out a number and then put it in
Yeah.
parentheses.
so
I mean, we try to be.
trying to
consistent
be
about-
consistent with in the formatting of, first place I see something is in paragraph D under permitted uses, 4th line down, where it says permit for temporary use, which permit shall be valid for 6 months. They have the word 6, and then in parentheses, we have the numeral 6. That's the model.
Yes.
I see.
Trying to be
instances
consistent.
where We're not following that
So-
model,
Yeah, trying to be consistent with that.
like
there's-
150.
Yeah, E has some. The written out part.
We also had done it with percentages too, hadn't we?
Yes,
Oh my God.
Are
There's another.
I wish we'd never.
you sure you want to continue? your
Yeah, I know.
contract with us?
Get rid of it.
Never have done.
Hard to search for
putting the
numbers,
words
because you have
in
to
the
search
new
for
one.
every number,
Yeah.
at least 5, 10s.
Look, it's not a big deal as far as I'm concerned. I don't mind if there's a discrep or a difference, if it happens one way sometimes and the other way the other times.
What is the significance?
What's the big deal?
I'm curious about that myself.
I think legal had told us at one time, that's the way you do it.
I think it's just nice to be consistent, but I don't think it's something that,
Well, if we're trying to be consistent, then we have to do the word and then the parentheses, because that's what we've done in all of our new stuff.
So like,
but we're hoping again that R2 doesn't get used.
Yes, it should never be used ever again.
For reference for people that already have it and pretty clear. If there's a number written out or Arabic, then at least there's, it's not like somebody sees the number 15 and doesn't know what that means usually.
Right.
Then let's just leave it as is and move on.
All right, should we, could I have a motion on the low density residential district, Article 9?
I make a motion to approve. Or send it to a hearing, or how do you want that worded, to approve? We don't approve till we're actually in a hearing, right?
No, we're not gonna set a hearing date,
Okay.
but set a hearing date.
I make a motion to accept Article 9, low density residential district R2, the November 21st, 2023 version. From Scott Sanders.
Okay, and we can set, if you don't mind, we could say with a hearing date to be determined.
That's fine.
That'll be
With a
applicable to
hearing
all
date to
these.
be determined.
Yeah.
At a later date here.
All right,
I'll second that.
so you have that motion, DG?
Mhm.
All right. Any questions, any further discussion? All right, hearing none. All those in favor signify by saying aye. Aye. Okay, Article 9 has been accepted with the intent of setting a hearing date in the future.
And how
Okay.
many are we waiting to do at one time?
Well, we're gonna do as many as we can, how's that? We're not gonna do it by itself.
Cause Matt, you get these next, you'll get to go through all of them.
Thank you, Scott. All right, how about Article 11, Planned Residential District?
I make a motion to accept. Article 11, the planned residential district, PRD. The final versions dated November 21st, 2023. With the hearing to be set at a later date.
Thank you.
Now for this one, did we want the numbers changed since it's potentially going to be used more than R2? Or do we still not care?
I don't care one way or another personally, but
Also, most
if-
of them
if
seem to be
somebody's-
written out
if
anyway. so-
somebody's particularly annoyed by it, that I wanted to change it, that's fine. I'm not particularly annoyed about
Well,
it.
If you could note, I mean, if this discussion is noted in the minutes and by the time you actually initiate them, maybe I update them.
Yeah,
Maybe I go through and try to find them all.
Yeah, this article looks pretty clean.
I was gonna say, I haven't found any in this one yet. I am just skipping, but
I'm just glancing through it again and because I wasn't looking for that before.
like even the percentages are written
And
as well.
what I've seen so far, it's been consistent.
All right, then never mind. I'll second it.
Um,
Oh, sorry. Never-
well, no, but in terms of discussion on the article, we've got this new article, I assume 23.
That one's separate. That's not a part of Article 11,
Gotcha.
but it is referenced in here.
That's where I was looking.
Yeah.
Where do we have the reference to 23?
It's in the first paragraph or second, under
Gotcha.
11
All right, I
or 1,
see.
yeah. Prime
All right.
residential district.
All right,
So
so
it's defined in Article 33.
20, okay, so where the motion is to accept Article 11,
Article 23, sorry, I said 33.
which does not include Article 23 is separate, like you said. Okay.
Yeah, Article
I have a question, excuse my disorganization. Article 23, the new one. Have we already approved that?
Hmm.
Do we have to approve that before we approve the PRD or have a hearing about the PRD? Otherwise, we're gonna have a PRD with no procedure article.
Then we have to do
We're
them
gonna do that
together.
one next.
Well, the
We have to,
answer
like,
to
do
the
it at the
question
same
is,
time.
we're not setting a hearing date for the PRD. But the question is that I think you may be asking, is that if we approve this, basically, we're then agreeing that we're going to have a separate Article 23 for procedures that we
Yeah.
will have to deal with.
Yeah,
And it will have to be approved or accepted by us to go along with this at the same time.
But as long as they're simultaneous. we're
Yeah,
okay,
and then we
right?
would take those forward for hearing on the, they would all be heard on the same hearing. We
okay,
won't have separate hearings.
Okay.
We'll have one hearing potentially for all four of the articles that we have here with us.
okay, got
tonight.
it. All right,
That answer?
yes.
Yeah. But right now, we're only dealing with Article 11.
Did we get a second yet?
Yes,
Second, yeah.
Give me
Virginia.
a second, okay.
And the motion was to accept Article 11
Mhm.
as written.
With a hearing date to be set later.
With a hearing date to be set in the future, and this, okay. Any further discussion? All right. Hearing none, then all those in favor of the motion to accept Article 11 signify by saying aye.
Aye.
Aye, opposed, no? Okay, Article 11 is accepted. And now Article 23. Now, that's the one that you were just asking the question about. Really. So these would become the new procedures that would be followed for PRD
Or any planned district,
or any planned district.
except conservation districts. Right?
Oh, yeah, it doesn't apply
Well,
to,
it's not so much I don't know if it's different between conservation district and a plant. I think it's a difference between
overlay districts. It
a
does not
planned
apply to.
district and an overlay district.
Okay.
It does not apply to an overlay district. Yeah. So any planned district, even if, but not a PRCD because that's an overlay,
That's an overlay.
Okay.
okay? But a planned industrial, planned commercial,
Plan PRD, PCD, PID,
that's it,
and PUD.
PUD.
If we keep that PUD, we haven't. I don't know about what we're gonna do about that, but. Those are the other four that are quote straight plan districts. Well, I'm sorry, not the other four. There's three new. We've already addressed PRD. So these would be the procedures that would be applicable to all of those.
I'll make a motion to accept the new article, section 23, procedure for rezoning to a planned district. The final version of November 21st, 2023, with a hearing to be set at a later date.
I have a motion. Is there a second?
There are some numbers in here that don't follow the pattern,
Yeah.
but I'll second it.
Yeah, certainly.
All right, it's been moved and seconded to accept Article 23, procedure for rezoning to a planned district. Any further discussion?
I just have one question. Does this apply to a PCD?
Yes,
Yes.
Well, not until we amend the.
Not
PUD.
still.
Yeah, okay. Got it, thank you.
Yeah,
And I think you're safe until you do that, because anybody that opens the PCD will see the procedure there.
Right.
Yeah.
And we may have to go back in here and say what it applies to as we make those other.
The PRCD is the only planned one that it does not apply to,
Thank you.
well, there's the CRCD.
of the existing,
That's
of the ones in our binder,
yeah.
of the ones in the tabs of our binder, Tom.
Yeah.
Yeah, the planned residential conservation
Yeah.
district is an overlay.
Come on.
It's the only one relating to.
Yes.
Thank you. That.
So far as this one's concerned, it would apply to all the straight districts. none of the overlays.
Great plan districts.
In our next binder, can we get our overlay
Not-
districts in italics or something?
Not the Euclidean districts. We are really the straight district.
I don't know what else to call
I don't either.
them. If I'm
Well,
referring
yeah,
to them
there's
as
the
a
five,
group.
you could say 51902 A and 51902 C, but that's a mouthful too.
A little much.
We moving on to Article 13?
Yeah, we haven't taken a motion, haven't voted on it yet. I said any further discussion,
Oh.
and that's as far as I got.
No more discussion from me.
If there's no further discussion, then we'll vote on the motion. All those in favor of accepting Article 23, procedure for rezoning to a planned district as submitted on 11/21/23, signify by saying aye.
I,
Aye, opposed, no. Okay, accepted.
To a future date.
And that brings us to the Plan Conservation District, PRCD.
We had to remind ourselves, right, that we did that one long enough ago. That we needed to make sure that we included that in the,
Yeah, this one,
like we started with this.
yes,
And we have a different procedure that applies to the PRCD, which is Article what? Where am I?
13.
no, but the procedure is.
No, because the procedure's not in here, right?
It's in the new stuff, isn't it?
Yes.
Which I don't have copies of that, so I don't know what it is.
I can't tell you off the top of my head, it's 30 something,
30 something.
30.
Okay, but I am
30,
thinking the right.
13 and
direction.
33, maybe.
Okay,
maybe.
got it. Thank you.
And the new one is the PRCD, the CRCD. Whatever else there was, that was it, just
Just those two, yeah.
Article 32 is for procedure subdivision. For the overlay. That's procedures. Article 31 is for multi-use. Article 32 is for the conservation.
You said 31? Or 30? 33.
Procedure to apply for conservation subdivision standards is 32. 33 is clustered residential conservation. 34 is mixed use. 35 is county line overlay.
You got all those?
I only needed the procedure because the bottom of that page, bottom of the first page says that you go to the article and it says 33, it should say 32,
Should say what?
32. Yeah,
It says 33.
So it's 32.
Yeah, it should say 32.
Mine says 32.
Yours says 32?
I'm on November 21st version, Article 32.
I'm sure it's not XXIII and it looks like two.
XX.
Oh, well, it's got
XXX,
32 in one place, 33 in another.
Where, oh, yeah, there it is.
Oh, yeah.
Now 32 is correct,
Okay.
and in the last paragraph where it says 33, that should be 32
It
also.
says
And
33
It
and
says
2.
33 in the last two paragraphs.
Wait a minute, let me see this. Let me read it again, make sure I'm right. Not complying.
Yeah.
It's correct.
Yeah.
3 paragraphs from the bottom
I
is
see that one.
correct. The
Yes,
next 2 paragraphs from the bottom.
it's wrong.
I see those.
Yeah, it's wrong in 2 places.
And the next page.
Yep.
33s.
Oh, there's two more, three more.
Yes, I can do that. There's quite a bit of them in that one paragraph even.
Yeah, the article.
So you've
30.
got six times.
Yeah, maybe I cut some.
You can do
Maybe I. So that.
Yeah,
it's
you
not-
better do a word search through that and make sure that.
Yeah.
All the 33s are caught and changed to
Yeah.
32.
So it's supposed to be 32 or 33?
It's supposed to be
32.
32.
Okay.
Yeah, 32 is procedures to apply. Procedure to apply the conservation subdivision standards. That's the title of that. I wanted to change that, but I remember a discussion about that, and then Holly didn't want that title changed.
And so what is the title? Procedure to a,
The title of Article 32. Yeah,
what is it?
procedures to apply the conservation subdivision standards.
Okay.
And that's now on the website. so
Yeah.
It's out there.
I just, yeah, I don't have the new stuff in this book.
I printed off the copies. Well, we had, DG printed them for us and I put them in the book. That's why I have mine with me.
I'll make a motion to approve Article 13. Land residential conservation district with the changes noted this evening. Changing Article 33s to 32s. This is the final clean version dated November 21st, 2023, with hearing to be set later.
Second,
I'm sorry, Virginia again?
I'll second.
Okay, thank you. I wasn't sure. I thought it was you. All right, so we have a motion to accept Article 13 with the changes noted. Regard to the reference in the article. So from 33 to 32. And the hearing date to be set later. All those in favor of the motion, is there any further discussion? Ask that first. Make sure, no further discussion, then all in favor, please signify by saying aye.
Aye.
Opposed, no. Okay, these are accepted as well. That's 4 we've accepted tonight. Some future time then, when we have a hearing, we're gonna have them all at the same time.
Got it. Thank you.
The last item here, presented by Scott is, the changes for in the development standard, where we're adding, section 2116 standards for regulating external impacts.
And those are mostly, and that, those are in all your other districts. Unless they came from somewhere else, it's this weird thing that's left over from the original. As far as I can tell, the original county code. And it just, I mean, it's a catch-all. It's a lot of things that you wouldn't worry about, but you want to put in there just in case, vibrations, air pollution, dust and erosion. And it just seems like it's a half page of text that can be saved by just putting it under general development standards and just referencing everything back there. We talked about that before.
Yeah, I think it's a good idea. We may have to change all of our other to mention section 21.16 or whatever.
Yeah,
Let me take that
Yeah.
stuff out.
And the good thing is it's either in there twice. Or it's in there once, so it's not like. Yeah. Well, in the interim, it will be okay because they'll be covered anyway.
Yeah.
And then when they're taken out, they can just be referenced to this spot.
There may be a general reference to the development standards. There may not be anything, there won't be anything in the existing ones to section 2116 until we would add it.
Just something to remember to do.
Yeah, as we go through, yeah. The ones that we've approved, if there's any need to reference it, you've got that included. I said approved, I mean accepted. Tonight. Okay, so with regard to these, this is, I mean, we had some discussion about it last month with Scott, but and then we agreed that we would go in this direction of adding it as a new section.
Do you want to have a motion to accept 16 and 17?
Yeah, well, yeah, and 17 is on the other side of
at
the
same
page, correct?
time,
Yeah,
Or do you want them separate?
limited home occupations.
Yeah, can we do them as one, or do we have to?
I think we could do them together unless there's a reason to separate them that someone wants to suggest. And I would say-
They're so different. I don't know.
Or they're all
They're all in the same 21.
one?
Yeah.
But they are in Article 21,
But
correct?
they're all the same article, just one hearing.
Right.
Yeah.
So one motion to accept these changes.
There are some number discrepancies though that don't follow our pattern.
I circled a couple, the 400 and the 20%.
Yeah, there were also no more than 2 additional parking spaces, it's just the letter, only 1 sign,
Oh,
1 square foot.
400 square feet. I assume that under 2116 F and G, the reference is noise standards of the Ohio Environmental Protection Agency. I assume this is none of this refers back to the US EPA. All the other ones above it refer to specifically to the Ohio Environmental Protection.
but which one again?
Well, I was.
Oh,
It was
You're
question
talking about F.
F and G both. Don't say specifically Ohio
Oh, yeah, you
EPA,
did say G also.
where B and E do.
What if, since so many of them reference that, what if the first time it's mentioned, I put OEPA in parentheses? And then every other time I just put OEPA,
That works.
That works.
and that shortens it a little bit.
So you'll just shorten it as OEPA. That's good.
So in, is the first time it's mentioned is in A, and after that, you're gonna put in parentheses OEPA. Am I correct?
Correct.
And then afterwards, wherever it comes up, it's just gonna be referenced as OEPA.
Yep.
Right. Which I know they're trying to separate themselves from the federal EPA. And they may tinker around with their name a little bit, but I haven't had anything specific about that. They don't just want to be the EPA. But until I hear something specific,
Yeah.
Seems like a bunch of hassle.
They are still
Machine.
referring to themselves as the Environmental Protection Agency, though in Ohio. Ohio EPA. Okay. Any other questions or issues relating to section 2116 here?
No.
Make a motion that we accept new language for section 21.1, or the yeah, the new language for section 21.16 and section 21.17. As submitted November 21st, 2023. With the changes we've noted this evening regarding OEPA and numbers. With a hearing date to be set later.
Second.
Did you
Yes,
say?
yes, I
Okay,
said.
sorry, I missed it. All right, we do have a second. To the motion made by Joni, and the second was from Virginia. To accept. The proposed changes for section 21.16 and 21.17. With the other changes that were noted tonight regarding the OEPA. Hearing date to be set in the future. Further discussion on this motion. Did everybody get through looking at the limited home occupation? Because all we did was take the existing language. I don't think we made any. Didn't make any changes in it. We didn't address the extended, but do we don't necessarily want that at this point, do we?
Yeah, I think we brought it up and we decided that it didn't belong here because.
It's different in different articles.
It's different in different articles. Sometimes it applies, sometimes it doesn't. I think,
And that would be a problem because the developmental standards are applicable to all.
yes,
So we didn't want that.
Yeah. Just wanted to make sure everyone's on the same page. Very good.
Okay,
Okay,
that's.
we have a motion and further discussion. Hearing no more, then all those in favor of the motion, please signify by saying aye.
Aye.
Aye, opposed, no. All right, motion's approved. Great. So Scott, we made a lot of progress
Thank you for doing all that.
and we'll have to make a decision then in terms of continuing the process and moving this forward. Where do you think we should go next? You have a recommendation?
So before we get to that, can I ask, are we going to set a hearing date for these now that we have? I mean, 5 is a pretty good chunk. Do we want to move them through?
We can potentially set a hearing date, but do we want to set that tonight or do we want to wait until January?
I would rather move them through instead of sit on them for a while, because we already with what the PRCD, we're like, did we finish that? Did we work on that?
Yeah,
So I'd rather just move it through and be done with it.
But the. Hearings are at our regular meeting, so it would have to be January
To be
8th.
January the 8th,
Which
you
is
can't
also
do it later than
organizational.
that.
We start with the organizational meeting, then move into our regular meeting, and we could have a hearing.
I mean, these
Yeah.
hearings are gonna take, what, 2 minutes? Cause we've already looked through it, it's basically opening the hearing, taking a vote, closing the hearing, like there's.
For our hearing on these should go quickly. I agree.
Yeah.
I wasn't necessarily expecting that we were going to accept them all tonight, but we have. I think what you made the statement earlier, I want to see us deal with them all at the same time.
And we can.
Yeah, I don't wanna do them one at a time, I'd rather. Do them in a chunk like this, but I think 5 is a good enough chunk that we can say, let's be done with them.
Yes, set a hearing at a number that would include all of them.
Yeah,
Yes, every one hearing, and we
It'd be
would
24 or dash.
set the date and we'd make the announcement that it'd be, and
Yeah, we don't have to notify property owners because it's language change,
right, it'd be application,
2401.
2401 would be the first one we do.
yeah, I say we move them through, cause otherwise we're gonna forget what we did and let's just be done with them.
Fine,
It's okay with me.
the DG will have to advertise them.
Mhm.
yeah, she will have to advertise. And they'll go back to you, but you already have them within 5 days. And then we will set the hearing date if we set it for January the eighth, then we can do that. That's within the time
Yeah,
period required.
I say do it.
All
Make a
right,
motion. Then I make a motion, then we set a hearing date for, do I have to list them all out?
yeah, we have to list them all.
All right, I don't have mine in numerical order anymore.
It's Article 9.
They're listed here, haha, never mind.
Yeah.
I make a motion that we set a hearing date for Article 9, low density residential district R2. Article 11, planned residential district PRD. Article 23, procedures for rezoning to a planned district. Which also includes, is that the one that includes the, no,
No, no.
okay. Article 13, planned residential conservation district.
And
And-
section,
And
And section 21.
16. Well, just say
16
changes
and
in
17.
Article 21.
And changes in Article 21. I make a motion that we set a hearing date for January 8th. At 7:45, because the organizational meeting is at 7.
We've got, maybe we should set it a little later.
What if we set
Only
it at
because we've got-
7:45 and then if we go,
Well, it's just us.
yeah, and you always say we're allowed to
Yeah,
start
we
late,
can
we
be
can't
late.
start early.
Yeah.
So let's just do it at 7:45
That's
on
fine.
January 8th.
All right, so we're looking at January 8th at 7:45 for the 5 articles that we've accepted here this evening,
I second it.
and seconded by Jody. Any further discussion?
let's do it.
Hearing none, then all in favor, signify by saying aye.
I,
Aye. Opposed, no. All right, so EG, you got that in terms of what the
Yeah.
announcement will need to be and then posting it on the website, et cetera?
Yeah.
Okay, very good. And going back to Scott, then Scott, the changes, the minor changes that we did discuss, can you go ahead and make those and then submit those copies? Because then those would be the copies that we would utilize at the hearing.
Yes.
So any of these articles that you make changes in would be the ones that we'd have to have. But we'll probably just do them all, we'll do them all as a package, so there won't be any confusion.
Mhm.
And that way I'll change the,
And you'll put the
Better, I'll
page
put a
numbers
different
on them
date
this
on that.
time around. Cause these weren't paginated.
Well, and they won't be until
yeah,
they're approved and put into the resolution by the county, correct?
I can
Well-
add temporary numbers, lot numbers, temporary page numbers.
They would be paginated the way that the articles are though, so they would have a
Yeah.
page. 9-1.
Yep. I just pulled them
9-2.
out into new,
So they're not paginated consecutively all the way through, so. Yeah, page 901, et cetera. If we, that's just helpful to have the page numbers on them.
in case somebody has a question.
Yeah,
Sure.
okay, very good. So just, you can just submit those changes then to DG.
Okay.
And then, once you have them, you can distribute or have the copies, and we'll have them for our meeting on the 8th.
Yeah.
Okay.
Then back to you asking me what I thought should be next. So I don't,
Right,
I mean, do you want to go through just conversion of some other planned districts over to that new procedure, or do you want to? Obviously not today, obviously, but talk about signs at the
right.
next one.
Well, the one that we did begin to do some work on, and then we just kind of abandoned it, was the FR1, if we want to go back to that. I'm asking everyone, not just Scott.
I think it still makes sense to do FR1 and AR1, since those are sort of the bulk of what we receive. And I think we're solidified on enough of the other things for now that getting those done makes sense.
I'm not sure how much change we'll make in the plan districts, but maybe in terms of the next batch, we look at doing the articles for FR1 and AR1, and then the other plan districts, as Scott was just identifying, and the procedures that we've already adopted, we'll go through and make whatever changes, but do them in order. Can we start with, or come back and start with Article 7? Which is,
AR.
yeah. Or should we go to 8?
I think it makes more sense to start with FR1, because I think more of our rezonings deal with that.
Yeah, it's
but
moving from 5 acres to 2 acres.
Yeah.
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 All right, so we would start, Scott, then with Article 8,
FR1.
FR1.
Okay.
Scott, a question for you. With sewers, are we going to need a 1 acre zoning? For those 5 acre and 2 acre lots that are within access of sanitary sewers?
I don't know that you'd say you need it.
If we don't have it, you can't rezone to it. I mean,
Right.
I'm just asking.
That put us in a legal bind because the revised code allows for smaller sewer, is that?
Well, I mean, once you get sewer, you can rezone to PRD, except for those that, and all these others that you. I mean, PRCD and PRD, unless you had less than the required amount of acreage. And if you're slightly under, I would imagine those people will ask for. You know, if you have 24 acres instead of 25, I'm sure they're gonna ask, but if you have 10, then. You could still do I mean, maybe that's. I don't know, what is your PRD? What did we just do? Is it 10 acre?
I think it's 10 acres.
Yeah. I mean, the concern then would be somebody splitting up and trying to do. Start seeing these little CADs everywhere with 1 acre lots. And maybe that's not the worst thing, but I don't know. I think you have a while to think about those. Think about that.
Yeah, I wouldn't want us to start working on that now. These other things are, I think, a higher priority because if somebody wants to do that, it's not going to be possible right now because sewers aren't there.
Yeah.
Whereas the other zoning districts, they could utilize. So that's why I'm thinking that we make those the higher priority to get those done first.
I also think you're gonna have a heck of a fight convincing the residents to allow us to put a new article in that allows for 1 acre lots. They've been very adamant about. not wanting it.
Yeah, once,
Yeah.
yeah. Once the sewers are imminent in terms of they actually start some construction,
Yeah.
then that, to me, that will be the time to address that rather than now.
And I would.
I still really want to encourage the plan districts.
I
Oh,
agree.
sure.
I think, we should encourage people to use planned districts. But you're still gonna have people with 2 acre lots and 5 acre lots who want to divide them to get their kids in, to get some income, to do whatever they're doing. And I think at some point, we'll probably need some mechanism for getting those rezoned. Whether, I don't know, we'll see. And I agree that let's work on the FR1 and the AR1 and get those in the book with whatever changes we're gonna make. And while we're doing that, we may be thinking about how would this work on a smaller parcel if we had the same kind of lot splits.
Mhm.
Kind of in the background of all of our considerations, even though it's never really mentioned.
Well, Brittany actually mentioned something earlier
Uh-oh.
about you think there's been a lot split somewhere. That's smaller than 2 acres.
Mhm.
Um,
I'm wondering how that occurs.
An old one or a recent one?
Sometimes my memory doesn't serve me perfectly, but I am fairly certain it is recent.
That there may be a situation where somebody did a adjacent property transfer. and it was supposed to be connected to the neighboring lot. We don't have a way to force that to happen, but then when they bring the paperwork to the township has to say, well, wait a minute, how'd this lot get created? And then it's, I mean, there's a discussion that would take place. But that's one way you can end up with a lot smaller when it wasn't supposed to be built on in the first place, but I'm not aware. Because all you have is this little phrase on the deed that sometimes can get lost from the deed that says this parcel is not intended to be a standalone parcel.
So that would be, so the only way you could tell is looking at the deed.
And I mean, we try to get that phrase on the legal description as well. The herein described acreage is not intended to be standalone lot.
Yeah.
And we have a map that shows all the stuff that we've reviewed over, well, currently it's the past 20 years. Now we're continuing to go back and load it in there. So, I mean, if I have an address or a location, I can look it up and see if we've reviewed anything.
Okay.
But I'm
Any-
just jumping to a conclusion. It could predate a
That's just what I
2 acre
was gonna
lot
say.
size, but just sat there empty for 30 years or however long that would
And
be.
there are some lots out there like that existed prior to November of 1988. And the language would permit those are legal lots if they existed that can be built on today, even though they may not meet today's zoning requirements, but they are non-conforming lots then.
Would they still have to meet county conditions for septic and stuff?
Yeah, they would have to meet those. But
And
that's
and
not
that
our
gets- That
jurisdiction.
gets really hard to do if you have like half an acre or something.
Yeah,
But they can make it work in some unusual situations if they're forced to, because the health department's not going to say you can't, I mean, they're going to put it back on the applicant and say, you show me a
yeah.
system that works.
Well-
They've gotten better at making systems smaller and more efficient. So
There,
maybe that's why they waited. Now they can finally get a system small enough.
I do know for sure down here on Center Village Road that there were lots over there that were non-conforming lots, and they have been built on recently, like within the last 2 years. But they're non-conforming lots, but they were legal lots, they existed,
Okay.
so they were permitted to build on it. But that doesn't mean that the setbacks and all that were waived. They weren't necessarily waived, they may have had to go to the BZA to get a variance for something. I don't know, but I'm just saying that the legal lot less than 2 acre minimum, 2 acre net acre minimum would be a non-conforming lot, just like this one we dealt with tonight. But that's a PRD, so it conforms as long as the PRD requirements are met. That's, otherwise they'd have to go back and deal with it as a non-conforming lot. And then they would be going to the BZA to deal with their request for a garage to be added.
So back to FR1, I printed something out in my workbook here dated March 9th. Did I ever send that out, or is that just, we didn't get to that point, so I didn't send it yet? And it's not very marked up. I mean, I have a few little questions and some things highlighted, but.
For the FR,
Mhm.
yeah, no, I think, that would be the place to start. And then-
I don't think we have that.
Okay.
I don't remember.
And I also think, remember we discussed,
Well, that
last
would have been,
meeting
like
that
he said, it was like. when
we
first
have a
started.
few. Like I have handwritten stuff in my binder where we talked about changing stuff before Scott was even working with
Right,
us.
and I noticed that in mine right here, same thing.
Yeah. So we had discussed it. I don't think we ever shared our comments with you, and I don't think you ever shared your
Okay.
markup with us.
And I can't tell from my notes if I just reviewed them.
But we never had discussion about them.
Okay. It felt like we Yeah, I think I just circled and did things on my own.
Yeah, you were starting to work on it, but we abandoned it to get to these other items.
Yeah.
And as we were dealing with strategic planning recommendations coming forward, that's when they started
Yeah,
coming in.
I
So it's
remember
Tom's fault.
working on that. for-
Yeah, we just set it aside. So that would be starting with what you have already done, Scott, would be the place to begin.
And I don't even think this is, I mean, what I have so far, I don't think it's worth sending you ahead of time. Because if I just hand it out whenever we decide to meet and we just start,
Yeah.
it would be good homework for you guys just to go through the existing language and to see if there are any unusual things that you might circle.
The one thing that I can recall that I remember some general discussion about with the zoning commission, I think I'm having a correct memory here, was when you suggested that we make some references to the ORC instead of reproducing the language.
Mhm.
Delete the language that's in here, like for agriculture purposes. And say agriculture purposes as defined in the ORC and the site to section number rather than restating
Which.
what's already in the ORC.
And there were a few things that I feel like we did that where we said C section whatever of the resolution instead of restating, so
That's
again,
right, we
following
did
the
talk about
general
that.
trend of just condensing.
Yeah.
So we'll find out all of those things that we did not finish when we pick it up again and start working on it. So Article 8 will be the first ones then that we deal with, FR1. Next one that we deal with, I should say. And
Does that mean that we need a workshop meeting in January?
well, that's just exactly my next question also. It seems like we should schedule that for January the 22nd.
Yes.
Okay, we'll schedule a workshop meeting on January 22nd.
I will not be here.
And it'll be 7:30. DG, would you make sure that you inform Kendra that we scheduled that meeting?
Yeah.
So that she can get the January 8th meeting and, well, actually, we have 2 meetings and a hearing now.
Yeah.
On January the 8th. And then on the 22nd, we'll have the workshop meeting.
Okay,
And the January 1st one should be,
canceled, yeah.
oh.
Yeah, that one, if it's out there on the posted anywhere, it needs to be canceled.
I'll check tomorrow.
So the 8th and the 22nd.
8th and 22nd.
I won't be here on the 22nd.
Oh, I'm sorry.
That's
Lucky you.
Gonna be out of town?
Yeah, can we also put in our posting that we don't have any alternates and they might be helpful?
Yeah,
Add that to the notice.
Yeah, when 3 of us are out at the same time, which hasn't happened for a long while, but if that were to happen, no alternate, then the meeting would be canceled. Hopefully that'll never happen, but it could.
It has happened at least once.
Yeah.
In the
So
last few years.
Okay.
one question before we get into the procedural guidelines that you wrote up in the application. Have we done with the zoning fees for 2024? I don't remember where we ended with that. Do you?
We haven't done anything with it.
Mike was gonna do something, wasn't he?
I'm asking, I forget,
Yeah,
because
I thought we were gonna have a discussion about adding a fence fee or something like that.
Well, Mike,
Among other
yeah, Mike
things.
Cannon did talk about,
Has
Fees.
Mike given you any?
But he
sort
hasn't
of
brought anything
updated
to
fee
us.
schedule?
we have to approve those at the
nothing
organizational.
that I think.
no, they're
you
set
guys
by
are
the
going to be dealing with
trustees.
yet. I
You gotta
don't know.
send them something, or they
Like,
just
we've
do it
looked at it, but,
themselves?
like,
They've
it's
done
only
it
like
in the past, they've just
a
done it
little bit
themselves.
of
Last year,
something
we
that's
did
like
make a recommendation to
final.
them, but we don't have to make a recommendation.
Mhm.
Not a requirement for us to make a recommendation regarding it.
Can
Look,
we
there was-
make a change to the fee schedule mid-year though?
We can make a change to recommend a change to the fee schedule at any time, yes. As we did it before.
I mean, the thing that brought it up is on this one, where it says the base fee is 500.
Well, that's because this one was from 22 when I did it.
Okay, so
This was in effect when we did the PRCD for,
Okay.
but now,
That would change. I don't, do you have the fee schedule online anywhere?
Just the normal Harlem Township fees.
yeah, it's up, it's online.
So.
What is the base fee for PRCD?
Yeah,
Is it different than any other rezoning?
Application for PRCD on acreage not reserved for open space, $2,000 plus $165 per acre.
So it is more.
That's the fee. So this, I have the 23 schedule of zoning fees.
The 2023, okay. And we had talked about there was one zoning permit fee that wasn't in here that came up. I think Mike must have those written notes. Yeah, and I know he was talking about a fence.
I know we've discussed a little bit, but I don't know if we've
Yeah.
finalized or have anything worth bringing to you guys yet.
If he's going to make a recommendation to the trustees for changes in fees, he will need to make the recommendation for the January 20th meeting. And Kendra just sent out a request asking for that information if there's something that needs to be addressed. I can ask Mike whether he's making any recommendations for changes in fees.
Okay. I thought they made those changes at the organizational meeting, but you're saying they do it at their first regular.
They can make the changes, and they have done them at their organizational meeting, but they can make them later.
Okay,
They can make them at any time,
okay.
but they will need to set some fees at their organizational meeting. So unless there's a recommendation for a change, they will approve the 2023 fee schedule for 2024. And Matt will be part of the decision in 2024.
Okay,
We don't, since Mike's not here, he hasn't offered anything to us to consider, but he did bring it up at one time.
I don't think we can move forward on it.
Okay. All right, let's see, the other items on the agenda that I had on here, the PRCD procedural guidelines and application form. And the reason that's on there, this is the form and what I sent you copies of. Scott, you don't have this because I know, but this was the procedure and the form that we use for the PRCD, Duncan Run Estates, which is now Duncan Run Conservancy. And I anticipated, because in all of those overlay districts, including that one, there's reference made that there's an application submitted. There's no application form that I'm aware of that has been recommended or come from strategic planning. But the applications are going to come to us. So since we use this for the PRCD that we have approved, is this an application that we want to consider modifying so that it can fit because the language that's on the application won't be appropriate anymore for all of the overlays. And the application language that's here won't be appropriate once the new, the revised PRCD language is adopted. But we don't have to make a decision tonight, but I wanted to make sure that everyone was aware that we need to do something about this.
Well, if we work on it, do you want to look, you won't want to put it on the agenda for, the 22nd?
22nd. Did I guess I'm gonna ask the question in terms of, if we put it on for the 22nd. I think what we have to give consideration to, and Scott, I need to get you a copy of it so you can consider it and maybe offer us some advice regarding that as well. That, the information that we're asking for in terms of the application and then the procedural guidelines that we may suggest, maybe we don't even need the procedural guidelines. Just refer them to the
Procedure.
the language that's in the zoning resolution. That's another question to be asked and answered. But then what's the application form going to look like? Because I created this since we didn't have one. It wasn't appropriate. I don't think, and I still don't think it's appropriate to use the current application that we have that applies to, because it talks, the language says amendment to the township zoning on the
That's wrong.
application.
Yeah.
And we don't want to implant that kind of thought in anyone's mind because
So do
it's not,
planned straight districts use the amendment to the zoning map application?
yes, straight districts, that's what it's for.
So basically, we just need two applications, then an overlay application and
That's my thinking,
Straight
yes.
application.
And so rather than plan residential conservation PRCD, we can just call it
An overlay. application.
Yeah,
an
an overlay
overlay,
application,
and that could be the CRCD, the PRCD, or anything else that comes up.
correct. So this language here is simply, because at the time that we did it, the PRCD is the only one we had. We adopted this when
Are there other townships that have overlay applications that we could?
November 22.
I don't really know a lot about. I mean, I see application forms when they come in as part of their,
That's when you see them.
yeah. I mean. Berkshire might, because they have a lot of activity around the interchange and they have two different overlays.
The main focus with the overlays is always going to be on the development plan, but it has to come in some fashion.
Yeah.
For the zoning commission to handle it.
Yeah.
Yeah. And it would just reference application to apply the overlay standards. And you would either have a checkbox for the one that it is, right?
Yeah, that's what I'm saying, this would need to be modified from what we currently have, because especially since we're changing the procedures now, there's gonna be one set of procedures that applies to all the overlays.
You'd want them similar so that they were branded the same.
Yeah. Oh, I don't have another copy.
No, I was there.
Want to go make a copy so Scott can take it with him?
I don't need a copy.
Oh, you've got one.
Yeah.
Okay, thanks.
Did you send this to us as a Word document or as a?
It's a PDF.
It's a PDF. I had asked her, did you find that, by the way?
Does not exist. The
Oh.
original Word document does not exist. Now, because I am like the third or fourth person that's been in this position in the last, God knows how long. There's a lot of there's like a lot of documents and forms and things like that that just don't exist as a Word document. And I'm gonna guess that's because they were either scanned in from something that was like 10 years old or
Yeah.
something like that, and it just made changes, but there is no original Word document, and I'm not gonna
Okay.
be able.
Because I created the draft and then it was typed by
Yeah.
Sherry Steele.
Yeah. So,
So that's the reason I'm saying,
there's-
all I have is the PDF file.
and that's the only version I have.
And you can't run your magic and.
I can, but it won't be the original file. So it'll always just be a copy of a copy, so.
But at least that'll give us something to work
Yeah.
from where we can,
Yeah,
track
make
changes.
make changes.
you're okay with that?
Sure.
I know.
We have to do something
It's not-
to begin working on it.
Yeah.
But this, I couldn't make any changes in it because I
Yeah.
don't have that, I'm not paying for that the software to be able to
No, it's
change
not
the
done.
PDF file. So my copy is a PDF.
Yeah.
And that's what I sent to
Yeah,
him.
yeah, I could make it an editable file, but yeah, whatever the original PDF is a scan of a scan of a scan.
Okay,
So-
and then you'll send that to all of us and we'll,
Mhm.
Yeah, please go ahead and do that.
Yeah.
But you've got the hard copy there. Now, the other thing is, when I found this on my version, I'm looking at it on my copy, it probably didn't come, maybe it did come through that way to you, I don't know. But it was, you could enter the data on the file.
That should be easy enough to do.
Yeah.
Can we make it look kind of like the other ones?
Yeah, I can-
Look like a pear?
Yeah, oh no, I'm gonna slowly but surely, they're all gonna match.
Remember, this is just a copy for us in terms of what changes we're
Mhm.
going to be making in it. It isn't something we're going to. I hope we don't have anybody that comes in right away. We have to have it immediately. Because we're not going to talk about the revisions in it until January the 22nd. That's what will be on the agenda. One of the items will be on the agenda.
So
And then
like, for the hearing that we're going to have for these districts. We will need an application cover, the cover sheet. I think.
Yes. What we have done for the changes in language. What we have done is utilized that, what's that form called? You use it with all of the overlay districts. Yeah. Well, that's what comes through when we take action on it. Application for
That's
amendment
what
of
we
this
were-
township zoning map. I filled out the top part of that. We never had a separate application form specifically for that.
I think Sherry just used to use the first page of the application.
That is what she did use. This. Application for amendment of township zoning map, but it just identified, it just has the identified information.
Mhm.
That's why I thought this is actually better. We don't have an application form. But it can be submitted just as a motion to be approved.
Okay.
Let's handle it, we can handle it the way, and I'll find the language that we used before when we've done the articles for the overlay districts. Use that same format that we used then. I don't have it here handy in my file, but I'll get that to DG so she can have that played. And it'll be up on the website as a hearing to be held. For our purposes, there'll be a document that'll come to us that'll list all of them on it.
Mhm.
And then it'll be application, as you call it, application HTZ 2401.
Mhm.
And that's what will be on this one too.
Okay.
Application for amendment of township zoning map. But we're not really amending the map. We're amending the language in the zoning resolution. So I'll find what we used with the overlay districts and then we'll just duplicate that. To bring the recommendation forward.
I will make a motion that. Brittany, make a motion.
I make a motion to adjourn.
Are you making a motion to adjourn or is
Brittany is.
we have to count on her to do that every time? That's all right. Brittany moved that the workshop meeting be adjourned.
Come on, Virginia.
Second,
You're right.
Virginia seconded. All in favor, signify by saying aye.
Aye.
Opposed, no.
Out of here.
No one voted no.
Do
We're unanimous tonight on everything, even adjourning.
we have to discuss?
Thank you all very much.
Thanks, I two comments.
Nope, we adjourned. You missed your.
Oh, no, you can do anything you want with Tom. We're adjourned.
I'm just kidding.
Well, I just wanted to give you guys a heads up